binding until we reach a price agreeable with the insurance company. A sub 2, subject to insurer agreement. So you'll say out there, well, this is a solution looking for a problem. But apparently, the department, and this is from talking with the department, has heard of contractors out there that didn't do that try to hold the customer to the insurance job even if the insurer denies the claim. And so that is their justification on why this law went into play. But in any event, it is a law. You're required to comply with it, so do so. Because again, with any of these, if you fail to comply with it, except for the formaldehyde notice, that's a little unclear. That may not be a license violation. The other ones that I've mentioned so far this morning, it's a license violation if you fail to comply. And now you have performance guidelines. Now this is kind of interesting. The Builders Association pushed this. And their original idea was a good idea. So I'm not ripping on the Builders Association when I talk about this attempt to try to get some clarity. And what the Builders Association saw was that you'd have all these defect actions, and you'd have these experts that would be at trial. And everyone would be talking about standards, and there were really no standards. What was the industry standard? And so you'd have the homeowner's expert say it's one thing, you'd have the builder's expert say it's another thing. You got these battle experts. It's kind of like buying a hooker. When you get an expert, they're going to say what you want them to say, and same for the homeowner. They're going to say what you want them to say. But juries look at it like the homeowner is the honest, clean, white-driven snow person out there, and you're a big bad contractor. And so because of that, in the battle of the experts, you're generally going to lose. If they have an expert that's credible and you have an expert that's credible, you're going to lose. And the Builders Association looked at this problem and said, we got a solution for this problem. We want industry standards, because then we don't have to have this battle of experts on what the standards are. Then we just have to look at whether the standards were complied with. A good idea. That's not what came out of the meat grinder at the legislature. What came out of the meat grinder at the legislature was, we're going to pass a law that says you have to have standards, but we're not going to say what those standards are. You get to decide what those standards are. Well, because of that, that doesn't solve the problem that the Builders Association was trying to address. It also creates another problem, because what the hell kind of standards are we going to use? We don't know. You guys haven't told us. You've told us we have to have standards. You didn't tell us what they are. But you've told us that we have to provide that to our customers. And that's what the law says. The law says that you have to, before you contract with your customers, tell them what your standards are that you're going to follow. And then you have to incorporate that into your contract. So there's another piece of paper in addition to your contract that you have to give them, your performance standards. Well, you know, we've come up with a minimum standard. I'm going to tell it to you here. That doesn't mean that's what your standards are, because NAHB, which I've got up there on the slide, has an entire book of standards that a lot of the new home builders are following and incorporating into their contracts. And you may want to do that. But at a minimum, code says, in the most recent, well actually from the 2006 version onward, says that manufacturer specifications are incorporated into code. So as long as you build the code manufacturer specs, you're complying with the minimum standards that you're legally required to comply with anyway. So if you make your standards on that extra sheet of paper that says that you're going to build to code and manufacturer specifications, that's your legal standard anyway. That's what you have to build to. So that's the bare minimum. So at least have that as far as your standards go. Now you could have aspirationally additional standards, just like NAHB has, an entire booklet of standards. I'm not going to say that's a good idea or a bad idea. I don't know. You can look at it both ways. You can look at it as a good idea because you can say, well, it's a sales tool. And we're going to build to this high level standards and our competitors aren't, and we're going to represent that we're better in the industry because of it. Okay, but I litigate. And I look at it from the other side. I look at it, which I don't generally do. We represent contractors, but let's say I was a homeowner's lawyer. I'm going to look at that standard book and I'm going to see that as a gold mine. Because if there's anything in there that you failed to comply with, I'm going to find it and I'm going to rip you up and down on the stand with it. So you can have a higher level of standards, but if you do, damn well better build to it. Because if you don't, and you have a defect problem, you're going to get pinched. But the law does say you have to have standards. So think about what you're going to have and give them a sheet of paper that says what they are and incorporate those standards into your contract. Just trying to see if there's anything I haven't covered here. All right, so these are the disclosures that you have to have. You have to have the formaldehyde notice. Again, if you don't have building materials that use formaldehyde, the law says you don't have to have it. But unless you're going to check all your building materials, just provide it. Then you don't have to worry about it. Statutory warranty you have to have. License violation if you don't. Home solicitation notice. Sometimes you have to have it, sometimes you don't, depending on which law you look at. You may have to provide it in any event, but the law is going to change here next session, most likely, and it's going to take away the issue. You're going to have to provide it. So I encourage you to provide it. Murphy's Law, somebody's going to screw something up, and it's going to cost you money. And if you have situations where sometimes you have to provide it and sometimes you don't, no harm, no foul if you always provide it. The insurance right to cancel, only on roofing and siding residential insurance paid jobs. So if it's a framing job, you don't have to provide it. If it's an interior remodel job, you don't have to provide it. If it's a wet house job, you don't have to provide it. But if you're doing roofing and siding, you have to provide it. If you don't, it's unclear what the penalty is, but it's a license violation. So provide it. And the last thing is the performance standards. You have to provide it. You have to give them a copy of the standards along with your contract. Think about what those standards are because the legislature didn't help you with that. And always provide that. If you don't provide that, it's a license violation. As I mentioned earlier, license violations are $10,000 per violation. There's other things that they can do to you. They can suspend your license. They can revoke your license. But in any event, any violation is a $10,000 penalty. So these are paperwork violations, I understand. But I see them all the time. And the department does generate revenue off of your industry for failing to have the proper paperwork. So I have the right paperwork. Takeaway on all of this. You got required disclosures, use them. Train your sales reps in using them. Make sure that your sales reps understand that if they don't provide these things, they won't be working for you anymore. It's your license, it's not their license. Protect your license. Recognize that your sales reps are going to do things that screw this up. So train, train, train. It's not enough to get a signature on a contract. It's enough to have the right contract, and it's enough to not overrepresent and misrepresent through the sales process. Now, selling is an art, but it's also part of contracting. So if your sales reps screw that up, promise them the moon, can't deliver, don't provide the right paperwork, it's going to cost you because it's your license. Now, these are disclosure requirements. You're required to disclose. You're not required to explain. And I'd be uncomfortable having your sales reps explain these laws anyway. They're laws. They're complicated laws. I've talked about, there's exceptions and there's case law and there's all this kind of stuff that bears on what the law actually is. That's why I have job security. Sales reps aren't trained for that. They're trained to sell. You don't want to send them through law school and turn them into lawyers so that they can represent exactly what the law is, if we can really determine exactly what the law is on these things. So what I've often encouraged is you have a folder. You have your contract on one side of the folder, and you have all these disclosures on the other side of the folder. And you give a copy of that folder to your customer. And your sales rep says, Mrs. Homeowner, you have a folder in front of you. It's the same that I have in front of me. And on the left-hand side is our agreement. We're going to go through that in a second to pick out your materials and selections. And on the right-hand side is a bunch of information for your benefit because we are a reputable company and we want you to have that information. And then go into the selections. I'd say 99% of the time the customer is not going to ask what all that stuff was. And if they do, say it's disclosures. It's disclosures that we provide because we are a reputable company. Read through them, at your own leisure. But then don't get baited into explaining what they all are, because if you do, if your sales rep does, they're going to screw that up. They're not going to explain them properly. And then there's a question of whether that explanation, even if your contract says it's not part of the contract, becomes part of the contract. Because there's a little thing called fraudulent inducement that most lawyers know about. The customer, when they get to their lawyer is going to train them into saying that that was one of the reasons, that representation made by that sales rep was one of the reasons that they entered into the contract, and but for that representation, they wouldn't have entered into that contract. Now you got an expensive lawsuit because your sales rep did something that they thought they should be doing, which is explain stuff that they don't understand. So it's disclosures. You're not required to explain what they are. You're required to provide them. Now Charlie Dernberger is going to be here at noon. He's going to be talking about this issue, this no rebate deductible law. And the law isn't brand new. The law is about a year old, a little bit, actually about a year and a half old initially. And then about a year ago, actually about 6 months ago, the law changed again. And initially it was you can't rebate the deductible. And I was out there with my clients saying, you should say hallelujah on this because you're giving your money away. It's your money. Why are you giving a deductible away? That's part of the money that's supposed to go to you so you can make a profit. Are you in charity? No, you're in business. You're in business to make a buck, hopefully more than a buck. And that's part of the bucks that you're making, and you're all out there giving the deductible away. And the answer is always to me, well, it's because everyone else does. Well, if everyone like lemmings jump off a cliff, are you going to jump off a cliff? No, you're not going to jump off a cliff. So to me, that's not a good answer. Now, I understand you're trying to get a job sold, and I understand that that answer is a good answer for you because you think you're going to lose that job if you don't rebate that deductible. But here comes along this law that says you can't do it on residential roofing contracts. That was the original law. And like I said, hallelujah, stop giving your money away. Then the law got changed, and the law got changed to apply to residential roofing and or siding contracts. So now it applies to siding as well. But the law went a little further now too. It's not that you just can't rebate a deductible. You can't give anything of value to your potential customer as an inducement to entering into that contract. So no sign credit, no lead credit, no free upgrade from a 3-tab to an architectural, although I know the pricing is pretty much comparable now for what you're paying on the two. So you can't give freebies. Well, in one sense, I'd say again, say hallelujah, because you don't have to give your money away. But it also complicates things, because you got educated customers out there that want you to give your money away and are working really hard to try to get you to give your money away. Be very careful, because if it's a residential roofing or siding job and you give your customer anything of value as an inducement to entering into that contract, you violated this statute. And the department considers this insurance fraud. The insurance companies consider this insurance fraud. Because on a replacement cost value claim, not an ACV claim, not an actual cash value, an RCV claim, where the insurance company is paying for the replacement cost of that work, they're not paying more, they're not paying less. And if you as the contractor are receiving less because you're providing some value to your customer for that work, you're actually doing the job for less. You're over-representing to the insurance company what the actual cost is of doing that work. Any deduction should go to the insurance company because they're only paying for the replacement cost value. Now that's the insurance industry's argument, and the department has picked that argument up. So it's considered insurance fraud. That's a big deal. You want to get your license suspended? You want to get your license revoked? Engage in fraud. Now there's a counter argument to that, and it's that the customer is providing you some value back. Now, irrespective of this statute, so don't think about the statute, but the counter argument is that they're providing you some value, so you're compensating them for that value, just as if you would pay a laborer. You know, if they're putting a sign in your yard, you're providing them the advertising payment for having that sign in that yard. And that argument used to work sometimes, and I used to make that argument. But on a residential roofing or siding job, that argument doesn't work anymore because it all comes down to whether it was an inducement to contracting. Now, you can say, well, the job's been going on now, and my customer wants me to do this and wants me to throw that in for free. Can I do that? I'd say it's questionable. I understand your argument is that it's not an inducement to contracting. However, when it comes out later and the facts change a little bit because people's memories get fuzzy or somebody tries to get leverage over you, or you're trying to argue it to the department and you're spending money with an expensive suit like me to make the arguments for you, do you really want to be there? I think the best solution is on a residential roofing or siding job, you can't give your customer anything. I don't care if it's at beginning, middle, or end of the contract job. You can't give them anything. And what you do is you blame the legislature. It's not your fault. They told us we can't do it. And oh, by the way, if somebody came by and told you they could, you can say, that's illegal. You don't want to engage in illegal acts, do you, customer? No, I didn't think so. So that's a good way of you keeping your money, because it's still your money. Quit giving it away. But again, Charlie Dernberger is going to speak a little bit more on this issue at noon here. So don't do it. No signer lead credits anymore. If you've been doing that, if you've got a document from my firm or another firm, or you created it yourself that says that you're going to give a sign credit or lead credit, rip those up. Don't use those anymore, because this law makes those illegal. Recognize it's your money. Don't give it away. And again, train your sales reps, because it's your license. It's not theirs. And what do they care? They care about getting a sale, because they're on commission. And some of them don't care how they get that sale. It's not their liability or risk. It's like this whole thing we went through with the banks just recently. The bankers took on all this risk, and then they turn to us and say, protect us from our own risk. And so they spread the liability to all of us. Well, you have that problem with your sales reps. The way it's structured, you're taking on the risk. Your sales rep really doesn't have any risk. And so they're out there representing you and saying things that may hurt you and may cause you not only money, but cost your license. So I think you need to train your sales reps very well and make them understand that if they don't follow these procedures, if they're out there trying to give your money away, if they're not providing the required disclosures, they're done. They don't work for you anymore. I don't care how good a person they were at selling. They're a liability for you, and an unacceptable liability, and they're gone. And if they understand that it's going to be their job, now they've got some risk. Especially if you have an independent sales rep contract that says that if they get fired for cause, or terminated for cause if they're independents, that they don't get any more money. So they don't have the jobs that they've sold, the money coming down. They don't have this tail of money that they expect that they're going to get from their bad acts. They're done. They're cut off. No more dollars. Can you do that? Yeah, case law supports that, as long as it's in your written agreement. So you can really put the hammer down and have some leverage on rogue sales people and make sure that they follow your procedure to protect your license, to make you profit. Now, these include some must-haves, and I'll try to identify the must-haves, but these are also some things that are a good idea, and again, I'll try to identify that in customer contracts. So as you review your customer contracts, these are provisions that I think should be in that contract. Legally required by your licensing statute for residential construction, you have to have a scope of work. Scope of work is also a good idea anyway, because it not only defines what you're doing, but it also defines what you're not doing, what's not included. Because we all know that construction jobs tend to grow as things are discovered. And you want to make sure that you have a well-defined scope of work so that when it goes outside that scope of work, sure, customer, we're willing to do that work for you. But we need to sign a change order, and it'll be additional cost for that. And so you have a change order done that includes that additional work. So a well-defined scope of work helps you. It also helps your lawyer if you're trying to enforce a contract. Because if you don't have a good, well-defined scope of work, what were you supposed to do? There's going to be a disagreement on that. When there's disagreement, that costs you more money in a lawsuit. It also makes it more unlikely. Makes it more unlikely that you're going to make to get paid. It makes it more unlikely that you're going to win. So a well-defined scope of work required by your licensing statute, include it. A description of the materials and work to be done. That's also a licensing requirement for residential construction, so include that in your contracts. A price or description of how you're going to calculate that price. So for example, time and materials. Or a sub-2 agreement like you have. We're going to do it subject to agreement with the insurance company on price and scope. You have to have that in your contract. If you don't have a price or a way how that price is going to be calculated, not only is it a license violation, because that's required in your licensing statutes, but it's going to be very difficult for you when you're trying to collect on that job to tell a judge or a jury